interesting panel and people want to keep on talking. But I think this panel is actually a nice segue from the last one, and it actually puts together the last kind of big issue around some of these investor recovery stories or issues, I guess. My name is Janis Sarra, and I'm at the University of British Columbia, Faculty of Law. And for our last panel, we actually have quite a wide diversity of people and different perspectives, and I think it's a lovely way to wrap up. We had a discussion at lunchtime whether the last panel are the people you least want to hear, or whether you want a strong panel on. My own view is that Osgood and Fair have put a strong panel on. So we're going to hear, I'm not going to do a long introduction, as Mary said in the last panel, you have the bio notes, but we certainly have a formidable panel. We're going to spend first about 7 minutes talking about their own jurisdictions, just to give you a comparative view, and then we will embark on some discussion and take your questions. So first we're going to have Sarah Bradley, who is the Ombud and Chief Executive Officer of OBSI, and who is in that role for roughly about 5 or 6 weeks now, so I think a really fresh lens on some of the evolution of it and also the current challenges. Going to be followed by Professor Mercer Bullard, who is with the University of Mississippi School of Law, who's going to talk about the Finra process and some of its current concerns and challenges. Third, we're going to shift over to our long-distance panelist here, Shane Tregillis, who's the Chief Ombud for the Financial Ombudsman Service in Australia. So we're going to get a glimpse of that and hope for some interactive exchange. And then fourth, last but certainly not least, for quite a different model, we're going to hear from Sujatha Sekhar Naik, who is the CEO of the Securities Industry Dispute Resolution Center for the Malaysia Securities Commission, and who is also, although it's a separate entity, she's on secondment from the Securities Commission, so she's going to talk a little bit about how one designs a different kind of process. So with that, I'm going to have Sarah take it away.
Great. Well, thank you very much, Jess, and so we'll thank Fair and Osgood for putting on a really high quality conference today. I've really enjoyed hearing from all of you and chatting with you on the breaks. I'll mention a few things about OBSI. We are a independent, not-for-profit organization that was established in 1996. So next year is going to actually be our 20th anniversary. We hear consumer complaints dealing with investments and banking, where the consumer has not been able to reach a satisfactory settlement with their financial services provider. And we have about 1,500 member firms. We open about 600 investigations per year. We receive, of course, many more inquiries than that, but investigation files, we open about 600 a year. And over the last 5 years, we've returned about $20 million in compensation to over 1,000 consumers. So that hopefully gives you a bit of a sense of what we are and our general scale. So we've been tasked today, each of us, with providing a summary of the history and challenges of our respective organizations in 7 minutes. So I've used up about a minute already, but I do want to touch on 4 challenges or significant historical issues that OBSI has been facing. These are going to be strictly high points only. The first is, as many of you know, OBSI does not have the authority to make binding decisions. So I'll mention a few things about that. We also have a situation of having multiple external complaint bodies in the banking sector. I'll mention that. The third issue is the loss of mandate over systemic issues that occurred last year. And the fourth would be that we have no mandate for insurance products. And so I'll touch on those four sort of major issues that OBSI has been and will be dealing with in the future. So first on the issue of no binding authority. OBSI, as most of you may know, doesn't have the ability to oblige any firm to comply with its recommendations. Instead, the final recourse that OBSI has against a participating firm that refuses to participate in its refuses to comply with its recommendation is what's known colloquially as name and shame. So we publish the name of the firm, publish the details of our findings. This has been in place for the entire history of OBSI, it has positive and negative aspects to it. On the positive side, it keeps our processes very low cost, very simple. And the fact is, it has been, our processes have resulted, in over 99% of our files are closed satisfactorily. So we publish very few cases actually get to that name and shame place. And in fact, for many years, it was never used. There was one publication in 2007 against a small mutual fund firm. But it wasn't used because, first of all, most cases did ultimately settle. And there was also concern about using name and shame, because once a firm is named and shamed, there's no benefit to the consumer from that. There's no recovery that will be realized by the consumer. And there's also the potential that it exposes OBSI as weak or toothless in that sense. It reveals to the public that we, in a very tangible way, that we don't have that binding authority. However, that all changed in around 2012 as OBSI really took to heart our obligation to clear up a backlog of cases and to close our cases in a very timely fashion. That, of course, meant moving cases through to final conclusion. And many of the backlog cases had reached an impasse in terms of the negotiations with the firm. So that was a goal that was taken on. It was a goal that was achieved earlier this year, but it did mean moving many cases through to name and shame that had been on the books for quite some time. So since 2012, we've published against 19 different firms, and those publications predictably led to some considerable feedback and reaction from industry. When something is published, that's sort of by definition what people hear about. The vast majority of our cases are settled, or we find in favor of the participating firm's position, but those don't get publicized. So this led to some critique on the bases that I already discussed about the consumer receiving nothing in those cases and the concern about our perception of weakness, but also from the industry. The overwhelming majority of firms do cooperate with OBSI and do ultimately comply with our recommendations, and they felt that they were unfairly tarred with the same brush when there was a publication. So there's been some concern around this. There's also concern that the existence or the non-existence of binding authority colors the entire negotiation process when a firm is dealing with OBSI. And we're currently looking into developing some quantitative data around this phenomenon. The concern being that when firms are dealing with OBSI and know that they are, even if they intend to pay the consumer, that they know that they have a bargaining range. Right? That OBSI may come up with a certain recommendation, but that they really don't need to pay that amount. That they will be able to reach a conclusion of the case by paying a lesser amount. Clients also know this, and so there's a concern that leads to settlements below amounts that we would otherwise recommend. So that's certainly an issue. I think there's been a lot of public discourse around this recently, and I think we need to consider binding authority. That was the 1 minute slide. I haven't got to 3 of my issues. We need to consider binding authority carefully. I think it would ultimately be beneficial to the vast majority of our stakeholders, both participating firms and consumers. But there will also be costs to it, and I think that's a factor that we need to carefully consider. I don't think I'm going to be able to get into very much detail on the multiple external complaint bodies for banking. Historically, OBSI was the only external complaint body for both banking and investment firms. In 2014, actually, very recently, the federal government made it clear that a competitive marketplace for external complaint bodies would exist for banking. To date, OBSI and one other organization, ADRBO, have been qualified in that context. I have concerns about this and with respect to the perception of independence, which is very important to us. We need consumers to trust us and to understand and believe that we are impartial as between them and the firms. I think that is impaired where there's a multiple complaint bodies. We also have in 2014 amended our terms of reference to remove our ability to investigate systemic risk. We now are obliged by regulators to instead report to them when we have detected a systemic issue. And we have been doing that. It's a relatively new protocol. And finally, the final issue I wanted to touch on is that we no longer investigate issues concerning portfolios that include segregated funds. Segregated funds are an investment product with some insurance features, and they're technically qualified as an insurance product and regulated by insurance regulators. So we are obliged now to refer those complaints to the Ombudsman for Life and Health Insurance. This, I think, is challenging because often there are dually licensed advisors selling both, for example, mutual fund and insurance products. And so those products can exist simultaneously in one portfolio, and when that consumer has a problem, they find themselves in a very confusing regulatory place. And I think it's unfortunate that we're not able to look at both types of complaints. So that's OBSI's challenges in a nutshell.
Mercer.
Thanks very much for the invitation to be here. Really enjoyed the conference and appreciate saving the best for last. I'm just going to quickly run through the essence of what is known as Finra Arbitration. So in the US, broker-dealers, like most places, have contracts with their customers, customer agreements, and virtually all of those customer agreements have a provision that provides what we call mandatory arbitration. Broker-dealers are required to offer their customers the option of arbitration when there is a dispute, and in response, virtually all broker-dealers have required that they offer mandatory arbitration if they have a dispute. So what that means is virtually all retail, what I would call sales practices or sales abuse cases, are being litigated in arbitration, and they are not being litigated in the courts. This is a Finra arbitration. Finra is the Financial Industry Regulatory Authority. Some of you may know the name NASD. It's the successor to NASD. Finra doesn't actually run Finra arbitration directly. It's an affiliate, a different entity that essentially covers its own costs and gathers arbitrators, pays their fees, and runs it as something that's somewhat separate from Finra, but over which Finra, I think, has a lot of influence. This does not apply notably to investment advisors. So in the US, a broker-dealer is one who, in the retail context, is in the business of effecting transactions. So that means someone who's commission-based generally, whereas investment advisors providing investment advice who are not being paid commissions and getting, let's say, an asset-based fee are not subject to this regime. They can separately have in their own contracts an arbitration provision, but it won't necessarily be Finra arbitration, which is what I'll be focusing on here. These decisions are binding, and they also are appealable, although they are appealable in practice, and there are almost no decisions that result in overturning an arbitration, so they're really very final in that respect. That's important because the arbitrators who oversee these adjudications are often not lawyers. Most cases will have 3 panel members. The chair will typically be a lawyer, but not necessarily. They will have minimal training. They're paid about, I think, $400 a day, and that's only for the time they spend in a hearing. So it's generally understood that you win your case sitting at a table that's not much bigger than this one, in a room about the size of this platform, and you shouldn't expect a lot of reading and research to be going on outside of that hearing. The smallest claims of $25,000 or less are overseen by a single arbitrator, with obviously just a single chair, and the chair of both a three-person panel and that single arbitrator will get additional training, but again, it's relatively minimal. Finra takes the position that it does not provide substantive law for the arbitrators to follow. Its view is that arbitration is an equitable court, so to speak, and they should reach what are fair outcomes based on their own sense of fairness. So what that means is that in arbitration, while you are obviously going to be drawing on sources of law, and that would typically be Finra rules, and it is, I should have mentioned, a self-regulatory organization, but it does have rules that are binding on its member broker-dealers, or SEC rules or securities law, it isn't necessarily dispositive in any given case. And again, these not being lawyers, it's something that you rely on in detail at your own risk. So another point I want to make is that these are individual cases, and FINRA recently ruled that you cannot force class actions into arbitration. Now that's gotten a lot of press in the US, but the class action law in the US is such that it would be pretty unusual to have a sales practices class action case. In order to get a class certified, you have to have a commonality of facts among the plaintiffs that typically you would be able to disprove if you point to the communications that most investors will have had on an individualized basis. Virtually every sales practice case will involve each member of the class probably having had phone calls and individualized interactions with the customers, so there really aren't very many class actions. So again, virtually all of the law on retail sales practices with respect to broker-dealer relationship is being established now in arbitration, and that has been true for quite some time. The most common claim in arbitration is actually a violation of the fiduciary duty, which is interesting because in the US, under the common law, broker-dealers don't owe a fiduciary duty to their clients. They are salespersons. However, in arbitration, what is typically argued is that you have a trust relationship of trust and confidence with the client. And then what you would do is you would get the client to provide evidence that you were relying entirely on the broker to advise you, that you didn't have the sophistication to understand all of the mailings they were sending to you, that you had a vulnerable position relative to the position of the broker. And we think those often succeed, no one really knows, but certainly the plaintiff's lawyers think that that is an effective claim, that being the most common one brought. Otherwise, the second most common is generally a suitability type claim, which is what it sounds like. It's not really clear how much easier it is to win a fiduciary case than an arbitration case because there are no published opinions. Based on lots of discussions with arbitration lawyers, they generally think that in a fiduciary case, the panel won't require that you show specific intent by the broker and that you won't have to show that there was specific reliance by the investor. The idea being that in a relationship of trust and confidence, you've invested the decision-making in the broker, although not technically having discretionary control, essentially as de facto control. So these cases are done by plaintiff's lawyers on a contingency basis, typically up around 40% of the claim. So they are relatively risky cases to bring. They are also what you might call profit motivated. These cases are only taken if plaintiff's lawyers believe that they can make money taking them, and the threshold for that is fairly high. In an arbitration, it is very difficult to have a case that is worth hiring an expert. So the case, virtually all the cases I work on as expert are not arbitrations because they can't afford for small dollar amounts to bring on an expert. So these cases are very driven on the plaintiff's side by the incentives to get a big settlement. On the defense side, what you have are outside lawyers who are hired, but almost always in-house counsel being part of the team. And what's interesting there is what I suspect is a lot more sort of repeat experience on the part of the defendants in these cases. than the plaintiffs, because while there is kind of an arbitration bar, a lot of these cases will be brought by the lawyer in your city or in your town who might never have brought a securities case ever. So this sort of raises two major issues that have been criticisms of arbitration. One is that the outcomes are unfair. This has been based on studies that show that the outcomes typically run well above a majority in favor of the industry to sometimes 60 or 70%, depending on what year you look at. I find those very suspect because obviously what gets arbitrated to a conclusion are only the cases that don't settle or aren't simply dismissed before they even get to the point of bringing them to the broker, which means that when you finally get to the group that's actually arbitrated and then the smaller group that doesn't settle, you have a set of cases where both sides have a difference in view as to what the value of the case is. So you would think that normally that would break out about 50-50. And in my view, that you've got repeat players on the defense side with a little better knowledge as to how individual arbitrators rule, I would expect an equal outcome to be about 60% in favor of the industry. So while that's not the prevailing view, that is something that is a view that has now led to most investor advocates opposing mandatory arbitration. Some legislation has been proposed, and while right now that's not going to have any legs with our Republican-controlled Congress, it is interesting to note in parallel that just last week, a member of Congress recommended that broker-dealers themselves be entitled to their day in court to get a fair hearing and not have to go before SEC ALJ. But there's no move currently to allow investors the same opportunity to appear in court. So maybe there will actually be some compromise between Democrats and Republicans on that front. So just very quickly, the second major criticism is, as we've heard something about today, their opinions are not published. So when I mentioned that we don't really know what the law is, what you have is the body of law that represents the rights of retail investors in the US is virtually unknown and unpredictable. So there's a huge amount of uncertainty here, which really goes to whether you can engage in real risk management inside a broker-dealer.
Terrific, thank you very much. Shane, I'm going to turn it over to you in Australia, and since I can't discreetly pass you a note saying you've got a minute left, but if you run over too much, I'll say would you wrap up.
Thanks for the invitation to participate, and apologies for not being able to be there in person. Very briefly, I just wanted to touch on similar issues that OBSI is facing, just from our perspective. A little context about the organisation that I'm involved in. We deal with complaints across all sectors of the financial services, insurance, investments, banking. We were formed in 2008 as the merger of a series of largely sectoral-based organisations. The rest of the scheme has similar jurisdiction in Australia. It deals with smaller participants. We receive about 30,000 complaints per year. We would accept or deal with 20,000, so that gives us some idea of the scale of the organisation. It's about 300 employees. In terms of decisions, we do make binding decisions, but that represents only about 10% of all of the matters we deal with. The rest are resolved by agreement or by other resolution mechanisms. In terms of the jurisdictions, we do have binding decision-making powers. Our jurisdiction operates as a matter of contract with our members. As part of that contract, it is clear that a decision is a final decision and is binding upon the financial service provider. It's not binding on the consumer. Maybe what I'll do is just talk a little bit about the context and history of that particular jurisdiction, because I know it's of particular interest in Canada. That jurisdiction, the binding nature of external dispute resolution, has been part and parcel of the system in Australia since it started. The first was the ABIO, the Banking Ombudsman Scheme in 1990, had that binding jurisdiction. So I thought I'd run through a couple of the reasons why I think that's the case. Partly it is a function of the history. External dispute resolution really came out of the changes in the finance sector happening at the time of liberalisation. We had a very active consumer movement, kicked off really from the famous Kennedy speech in the US, but a very active consumer movement in financial services that has always played an important part. We had a number of figures, key people in the industry who recognised that increasingly consumers would want alternative redress. So a lot of the industry schemes started out of that with government pressure behind it. In the mid-1990s, across not only financial services, we have dispute resolution in telecoms, energy and water. A set of general principles were formulated called the benchmarks for effective external dispute resolution. One of those key principles is that decisions of external dispute resolution should be capable of being binding, and that's one of the compliance mechanisms. In terms of financial services, we had a number of major sort of inquiries into the financial sector. The Wallace inquiry in the mid-1990s led to the current sort of regulatory regime, regulator, licensing regime. It required all financial service providers to be licensed, and as a condition of that licensing, needed to be a member of an approved external dispute resolution scheme. That meant that the regulator then formulated the standards for approval, and one of those standards which binds us is that the scheme is required to ensure that members abide by its decisions. So that is one of our regulatory approval. In terms of the courts, they have also been supportive of external dispute resolution. We've had a number of challenges as a matter of contract to our jurisdiction. Typically, they have treated FOS as equivalent to a private tribunal. There's a number of cases around private tribunals, and have strongly supported the contractual basis, including the binding nature of the FOS jurisdiction and authority. And then I suppose the other part of the inquiry, the picture more recently, is that there have been, again, there's always parliamentary committees, I'm sure they are in Canada, and government inquiries. We've just had the Murray Financial Services inquiry. Again, it has come out strongly supportive of the important role of external dispute resolution and the current framework plays, really supporting consumer trust and confidence. So it gave a tick of approval, and recent industry inquiries, parliamentary inquiries into a number of the failures likewise have supported the strong role. Improvements required, but have supported our strong role. And finally, just as part of that context, at least in Australia, the industry ombudsman is recognised as part of not just the industry, but really as part of the broader picture of access to justice. Been a major review done by our Productivity Commission here in Australia, and it talked about the different mechanisms by which Australian citizens can get access to justice, and certainly the role of the industry ombudsman was recognised as an important part of that access to justice system. So sort of in summary, we've had binding jurisdiction. Our decisions are published, but on a de-identified basis. So we do not publish the names of the financial service provider or the individuals. So that's the context, just for comparison purposes. The challenges in terms of enforcement, how do we enforce? The primary mechanism is that under our rules, an unpaid determination is grounds for expulsion. We have a sort of formal process, it's quite complicated, but we will expel a member for failing to pay a determination. That has consequences for them, their licensing status. It can be a trigger for the regulator ASIC to take action. We do refer them to ASIC for serious misconduct. We regard failing to pay a determination as serious misconduct, again a trigger for potential ASIC action. In quite rare occasions, we can take proceedings for specific performance. There's always challenges in doing that, and I can come back to that. Typically, consumers do not have the resources to enforce their own decisions in their favour. One of the big issues we've got at the moment is that works okay when firms are sort of alive, but when firms go into administration or insolvency, we have some serious issues about unpaid determinations. Currently, we've got about $12 million of unpaid determinations as a result of firms going into liquidation, insolvency. PI does not, professional indemnity insurance does not work in those circumstances. It's a major issue, particularly in our investments jurisdiction for smaller firms. We've been an advocate of a last resort insurance compensation scheme as a way to deal with that. We do have a systemic issues obligation. We have a formal obligation as part of our approval, both to review, investigate, deal, and to report systemic issues. We have a separate systemic issues team that does that. It's a very active part of our functionality. So I might stop there, and it's a quick overview of some of the key issues that I think have been raised so far.
Thank you.
Okay, thank you. I think I'll just take you through very quickly how we will establish our framework, and then maybe touch on some of the challenges that Sarah had mentioned for the sake of for time constraints. We basically were set up after very, very comprehensive review and consultation with all the stakeholders in the market, actually. And there was a steering committee comprising stakeholders looking at the research that had been done, the benchmarking that had been done by the Securities Commission. And one of the benefits, I guess, we have in this globalized environment is that we learn from the hindsight experience of everyone else and our peers, and then fit it into our own context. So some of the main primary characteristics that we found was important to have was that apart from the fact that the service needed to be easily accessed and cost and time effective, it needed to also have certainty and closure for the parties concerned. And from that context, it was important that there was finality in the decision as well. And there was therefore our decisions are mandatory on the members. There was need for compulsory participation as well by members. So our scheme is basically mandated by regulation, similar to the FOS in Australia, and members are licensed intermediaries in the market, brokers, fund managers, unit trust management companies, basically the whole spectrum of the capital market intermediaries are deemed to be members of SIDRC. They don't have a choice in the matter. They have to comply with our rules. A breach of compliance with our rules and specifically with the award would be a breach of the regulations and licensing conditions. So that would then, would be something that we would report to the Securities Commission for action to be taken. We do have similar ability to suspend or expel, but with the consent, with the approval of the Securities Commission. So essentially our enforcement tool is really the Securities Commission, from the perspective of there being a breach. The whole show cause thing would kick in, and then they would take any action that they can. We don't have a name and shame kind of tool. And I think that was intentional because they didn't feel that as a first stop that was effective or would be in balance necessarily always with the finding, with the conduct issue that came up, because sometimes some of the findings are not necessarily related to misconduct. It could be related to many other things, systems failures or process issues or misunderstandings. Could be any one of that comes out with a decision against the members. So it was felt that the impact on the market as a whole, if we named and shamed, didn't justify that as a first stop measure. Probably after the Securities Commission took steps and undertook any admin action, however small, we would then be able to, move forward that way. Apart from that, I think, let me see, one of the other things that we talked about is whether we have any other body, any other ADR body, in the capital market that's been set up. The policy thinking on that front was there should just be one body that's approved. While the Securities Commission has got the ability to approve more, they took a policy call to just limit it to one, and they felt that that was important to prevent arbitrage, to ensure that there was proper regulatory oversight. They felt it would be better for investors as a whole to know that there was one place to come to, and there would be consistency of approach to decision making, approach to the rules that are applied. For the financial markets, we've got a financial mediation bureau that's under the central bank. And on that, there are some overlap issues which I think the OBSI also face over here. And we handled that by actually setting up a working group with the central bank, the Securities Commission, the Financial Mediation Bureau, and ourselves to ensure that if there are overlap issues, they don't fall through the crack, and that the approach to dealing with them is consistent. Because, from the capital market perspective, it's very conduct driven, and that's very different from how the central bank, approach to oversight is. So we actually work very closely together to ensure that the outcome is something that reflects the sales practices and regulations, okay, until 1 minute, that exist. And we've actually worked very hard to and I think we're almost there, to get the central bank to agree to the commercial banks becoming our members, so that we don't need to worry about overlaps. The distribution chain is such at the moment that products go through the commercial banks as well as licensed intermediaries under the capital market regulator. And the move is that those commercial banks will come under us, and therefore all cases involving capital market related products or services will come to SIDRC. One of the other things which I thought I should just mention is the earlier panel session on compensation funds. In Malaysia, we do have a compensation fund. Previously, there were several of them. The exchange ran one, and then you had the fund management industry, etc. That's been consolidated into one single capital market compensation fund established by the Securities Commission, but with a separate independent board. And they would actually pay out, they used to pay out for fraud and defalcation cases if it was found to be justified. But now it's been limited to only instances when the firm is insolvent and there's fraud, defalcation, or mis-selling involved. If the firm is not insolvent, it doesn't fall through the cracks, it comes to SIDRC. So basically the thinking behind that is, if the firm is at fault, the firm needs to pay unless they're insolvent. Okay, let's wrap up time. Okay. Some of the challenges that we've had, I think funding has been a challenge. We've been grandfathered by the Securities Commission so far. We have to go out to the market, and we have done our studies, and there are options on the table, but we're trying to manage it in terms of equitable apportionment across the varied member intermediaries that we have, as well as to try and manage the perception of conflict, to perhaps get some kind of continuous funding source also coming from the regulator or the Capital Market Development Fund. One of the major challenges we have, which you clearly don't have, is awareness, because we've been around for 4 years. I think the first 2 years they focused on putting the nuts and bolts into place, but our awareness on the part of the investors from the roadshows that we have done is minimal, really, really minimal, and that is that demonstrated in the number of cases that we have. We do, from our roadshows, see that people value the service and are happy to hear about it. And we've now actually applied to the Capital Market Development Fund because we've got no, funding source to get money for awareness and capacity building, because we feel it's really important. And that's the other characteristics I think that's really important, is we feel that the panel, the mediators and adjudicators that we have on our panel, they need to be very informed about the capital market so that the decisions that come out are informed. They need to have experience, the necessary experience of the capital market, as well as dispute resolution, being dispute resolution professionals, and that combination is really imperative for them to be on our panel, because we feel that actually also buys in, gives us credibility with the market in terms of the decisions that come out. So I think that's an important component.
Thank you. Okay, we're going to turn to the questions now. We've got several questions. One that came in early that I think is partly addressed was whether the panel could differentiate between public and private in terms of both conference title but also investor recovery. But let me rephrase that a little bit to say, are there particular obstacles about the structure, whether public or private or a hybrid, that really create barriers to investor recovery? And maybe, Sarah, you can start with you, including whether you think that the OBSI should also regain its mandate to investigate more systemic problems.
On the first part of the question, I think both public and private schemes can work. I don't know that that's necessarily an essential differentiator. I think they're different, but they can achieve the same results for participating firms and for consumers. Even the private schemes, such as ours, are still regulated. So we're required to comply with fairly extensive regulations on both the banking and the investment side. And so, although we're not a public body, we're certainly answerable to public bodies, and I think that's generally the approach taken in most countries. On the second question about whether I think we need to take back systemic risk, I'm not sure. There's a new system, and the new system is systemic risks are reported to regulators, and I think that's a system that could work, and I think it'll take a little bit more time before we really can form an opinion about that.
Shane, did you have any views you wanted to share on this topic?
I think both public and private can work. I think it depends on the history and context of each jurisdiction. So in our jurisdiction, the history is, some of my colleagues has characterised, external dispute resolution has been the sort of great tripartite adventure where government certainly played a role, but the buy-in of the industry has been incredibly important, and we've had a very active consumer movement, and that has been part of the sort of ingredients that has been quite a successful model. There is a pension superannuation tribunal in Australia that deals with trustee disputes that, given the nature of those disputes, is a statutory body and is effective as well. So, and UK is clearly a hybrid body. It's set up by legislation, but has a private sector board. So I think it very much depends on the sort of context. In terms of systemic issues, it is seen, it's an interesting area. It's certainly one that's developed. We are very active in that space. The issue for us is to make sure we don't sort of duplicate what the regulator's doing when the regulator becomes active. So we report regularly, and our discussions have certainly been much more intense about which matters we deal with and which matters we don't deal with. My own view, we deal with them confidentially, so we don't name and shame, and we don't actually report names to the regulator unless requested. My view is that the system has shown to be effective, and we do get the cooperation, particularly from the major players, to sort out issues. So to me, it seems to be working, but it is certainly something that gets regularly commented and discussed by parliamentary and other committees about, is it working, is it not working? So it's certainly work in progress.
Thank you. Did you have anything to add, Mercer?
Sure. It's interesting that the Finra rules governing arbitration are really the public part, and when I mentioned that we don't really agree with the view that you should have competence in capital markets when you're adjudicating these issues, Finra, I guess a few years ago now, has allowed the plaintiffs to choose to have an all-public panel, which means that they can choose to have no one with any experience in the financial services industry at all, and that is a very popular choice. So Finra has made that option available, which is Finra's fault, but it is the plaintiffs who are often choosing that option because they have so much suspicion about anyone who's had financial services experience being on the panel. And then another interesting development is that under ERISA, which is the law that governs retirement plans in the US, the Department of Labor has now made a proposal where essentially what it's doing is it's creating a duty of loyalty which currently doesn't apply under the law to individual retirement accounts. It is applying this duty of loyalty by forcing broker-dealers to adopt a contract that then would be enforced in Finra arbitration. So you have a completely separate regulator now using Finra arbitration to enforce contractually what is not currently a legal obligation of the broker-dealers under our retirement statutes.
This is a question for both Shane and with respect to Malaysia, and that is, are lawyers used in these processes? Shane?
Internally or externally?
No,
So I've got specialist ombudsmen who, ultimate decisions all are legally qualified, although our jurisdiction is sort of equitable, it's fair in all the circumstances, taking into account the relevant law and industry practice, but it's a fair in all the circumstances. But our industry ombudsman, typically we do seek, deal with unrepresented applicants, but in some of our jurisdictions, such as the investment area and life insurance matters, we do have lawyers or other forms of advocates acting for people, and we have seen the emergence in our credit jurisdiction of what we call credit repair companies, those companies that offer consumers the ability to fix their credit rating, which we consider quite a problem because we do think they are charging people for a free service and often are not very helpful. Some lawyers who represent customers before us are helpful and some are not so helpful, if I can put it that way. But we are designed as a system that is intended for unrepresented applicants, but that does get complicated in some of the more complicated investment disputes.
I suspect that was what was underlying the question. And Sujatha, you have the last word because we're almost out of time.
Well, no, we don't allow lawyers in the dispute resolution process itself. They can be there, to advise them before they come into it, or on the peripheral of it, but not within the system. Obviously, the vendors come in armed with their in-house counsel, and our approach is the mediator or the adjudicator actually plays that balancing role. We do have an investigation before the case gets to mediation, so there's a case report, a lot of work is done and provided to the adjudicator to help them. And they play the role of ensuring that the unrepresented investor, the information that's on the table is on a level playing field, that everyone understands it. And that can actually work for the member as well sometimes.
Okay, thank you. So you can see from just these really brief presentations that we could have done an entire afternoon on each of these structures, but hopefully it's whet your appetite to think about how we might fashion some of these processes in Canada going forward. So with that, will you please join me in thanking our panel. Now I think we're turning it over to the conference closing.